Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions and National Construction Document Service. Today, we have a fabulous webinar that's going to be conducted by Patrick Edgerton, who is an expert in construction lien law. And today, our topic is a contractor's, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Patrick.
Hello, everyone. I am honored to be here today. This is my first seminar I'm doing with Miss Ariella and her SunRay Notice Company. And I love giving seminars. I usually give them to lawyers and judges, so it's actually going to be interesting to give it to a bunch of contractors and subcontractors. And I do miss doing these in person, seeing everybody's smiling faces, but we'll do the best we can. Now, I do know that this is limited to 20 minutes, and so I want to cut right to the chase. Our firm does do tons of litigation, especially regarding mechanics and construction. But in this seminar, as stated by Ariella, we are trying to deal with like the step-by-step process to getting paid as the contractor subcontractor side. First of all, written contracts. They are important. Ironically, most of the time they're not required to win, but without them, it makes it hard to define the scope and the prices, which leads to the next part. What is the most important thing to include in a written contract? I sometimes see these contracts written by lawyers that have 14 pages of single space, small type, these terms and conditions and what have you, which are fine. But there's really key things that when you actually litigate, not just draw up contracts, that you like to see. One is the scope of work and the prices to be charged. This is so important, everyone, because the debate comes in many times when you deal with homeowners or other property owners as to what was included in the scope of work and the price to be charged. We all know that sometimes a contractor has in mind what they believe is included, but that's not always equates to the same or similar what the owner believes is included. So I recognize there's a balanced approach to this. For a multi-million-dollar job, you have drawings with specifications. I get that. When you have smaller jobs, many times it's just a list. I know you have to take a balanced approach. You don't want to spend $20,000 to do a $10,000 job, but it is important to make sure you have an accurate scope of work and the prices to be charged, and at least a balanced approach depending on how big the job is. I get it. Next, the attorney fee provision. I find that I'm amazed at how many of my clients come and they don't have any attorney fee provision in there, because that does give you some teeth if you have to file suit. Just so you know. Oh, I forgot to, thank you, Ariel. I forgot to move my screen apart. It's best if it's in your favor, where they agree to pay your reasonable attorney's fees and costs, but many times it's fair to have it as a prevailing party clause. When you see that I gave example language, it does not have to be exactly that language. But attorney fee provision, if you have to file a lawsuit, does have some teeth at least into trying to win it. It's not always automatic. The judge will have the final say as to whether or not you win attorney's fees if you're substantially victorious party. Many times judges have their own opinion. It's all over the place as to how much they'll give and when they'll give it and if they give it, but it does give you at least a better opportunity to settle with the defendant, knowing that if they lose, they might have to pay your attorney's fees. And just as I was about to explain before, is I explain seminars in terms of litigation, because these are things that come up in my litigation regularly. When I give my hour mechanics lien seminar, and I have, I think, a 26-page outline for that, literally over 85% of it in my outline is stuff I've actually litigated. And when I tell people that, they're actually surprised. So don't forget the attorney fee provision in there. Obviously, if it's your contract, just make a customer agrees to pay you, but be willing to do prevailing party if you can. Sometimes other people want it just their side. I don't like that. I usually at least think a compromise is prevailing party. If they aren't willing to do prevailing party, that may be one of the red flags that you need to think of when you are thinking of contracting with either this general contractor when you're the sub, or the property owner if you're the general. So now this is the part that comes up, is venue. Of course, you want to sue in the county that's close to you. I'm in DuPage County, Illinois, where we've been here since our firm's one of the oldest firms in DuPage County. We're very local. That's my first choice. Kane second, what have you, because I'm there quite a bit as well. But if for you probably want a county near where you are located, because that's your home court and what have you. You can put a forum selection clause, is what they call it in there, where the parties agree that in the event of litigation, that the venue shall be DuPage County, Illinois. Now, when I say venue and personal jurisdiction, those are two separate concepts. Personal jurisdiction has to do with whether or not you can sue someone here in Illinois. And now, when you're doing construction here in Illinois, doesn't come up too often, but it can if somebody tries to hire you for not Florida, it's pretty far away, but for Indiana or Wisconsin or Iowa. I get that quite a bit. If you can slip in a personal jurisdiction where they agree that in the event that people have to enforce the terms or defend the terms of the contract, that Illinois shall be that each party submits to the jurisdiction of Illinois, that at least gets you in Illinois. And then you agree that the venue shall be, and pick whichever county you want. So personal jurisdiction is a state concept. Venue is generally a county concept or a federal versus state court concept. So I think it's important, if you are especially commercial, if you can put that in there, that makes it more efficient for you, and it makes it more efficient for the litigation if it's near you for your purposes. Now, if they have to travel, so be it. But I'm trying to explain the concept of this getting paid as the persons who are doing the work or contracting to do the work. However, there is exceptions. One is if it's consumer, you have to sue where the contract was signed or the defendant resides. And when I say consumer, the consumer they kind of use the same definition for the Fair Debt Collection Practice Act, the Consumer Fraud Act, the Family Expense Act. It's basically done for someone's personal use as like their home or what have you. Now, sometimes people think residential means commercial, consumer, not necessarily. If you're contracting with a landlord for a tenant unit, that is not consumer. That's actually technically commercial. So, but if it is consumer, you're contracting directly with the property owner for their home, you have to sue where the contract was signed or the defendant resides. I actually had a lady who contacted me where she lived in Kendall County. The contractor resided in McHenry, and there was a form selection clause, and I'm surprised the lawyer sued in McHenry, and she couldn't afford to hire me because the dispute was only like $3,000. I told her what to do, and she was actually able to file a counterclaim under the Fair Debt Collection Practice Act for $1,000. And the lawyer actually paid her $1,000 during the pendency of the litigation in order to get that part of the case dismissed. So remember that consumer, contract signed, or where the defendant resides. Commercial, or i.e. non-consumer, you can sue basically wherever the transaction took place, and where if there's a form selection clause where you put in the contract where it should be. So keep that in mind. Next, okay, arbitration clauses. Arbitration clauses, I'm going to be blunt, are bull. They are a barrier to entry to getting paid. We are right now we filed suit in a lawsuit that's about a $300,000 case. There was an arbitration, AAA in there. And AAA, they're good quality people. Now, that's not the issue. They're just very expensive. My client, just to make the demand at AAA, is going to be, I think it was about $4,200 or $4,400 to proceed with arbitration. So our experience is it is not cheaper. It is not quicker on average than just going to court. Who do you think pays for the judge? The people pay for the judge. You are not paying the judge's time. And keep in mind, for arbitration, you're not just paying the demand to get started for the arbitration facilities. You then have to pay the arbitrator, which on average is probably $400 to $600 an hour. And that gets expensive because usually what the arbitrator will do is they'll say, okay, I'm going to need an $8,000 advance, $4,000 from each of you. That gets very pricey. So unless you want to deal with the cost of arbitration and the arbitrators, I generally recommend against it. So it can be faster, but you're going to be paying a prime dollar for it. But keep in mind, it only goes fast if both parties want it to go fast. You might find this hard to believe, but if one party wants to slow it down, it's not that hard to slow down a case. It's hard to stop a case, but it's not too hard to slow it down. There is an exception. When you have a more complex case with multiple parties. I had one case, sometimes you get mechanics lien cases that they just go bad. There's a dispute between the property owner and the general contractor. It's a multi-million-dollar case. Well, whenever there's a dispute, what you guys have learned between the owner and the general contractor, all the money stops. It just happens. Even if the contractor might have something to do with structural steel, that seems to be where it blows up the most when it gets to be the biggest litigation. the money stops and they just stop paying everybody. Then you start getting multiple liens in place, and when you file suit, I think I've had up to 30 parties to a lawsuit before, where everyone has their own lawyer. Each subcontractor and each subcontractor, which is usually the material providers, have filed a claim for lien, and we have that much litigation. You know how hard it would be to try to litigate a mechanics lien case with 30 parties before a court? It would be very difficult. So I have had it where an arbitrator then will basically take parts of the case where they try to schedule which part you litigate, meaning the electrical contractor, the plumbing contractor. Now, could something come up and your lawyer's not there that could adversely affect you? Yes, it could. If something comes up between the general and the owner and you didn't have your lawyer there paying them, but it does provide for a more balanced approach. Generally speaking, judges want everybody there. I have tried in the past to get judges to not formally sever a case, but basically treat it like litigate this part and this part and this part. And generally speaking, the judges will not do that. So if you have I recommend not agreeing to arbitration in the contract. If you think it's better after you do it and the parties agree, then I find it's more effective. Or if it's a more complex, expensive litigation, meaning with multiple parties, then you might want to consider it as well. Keep in mind that if it's not in a contract, it doesn't mean you can't do it. It just means everyone has to agree to it later. Next, written change order requirements. Why people keep hiring lawyers that don't do litigation and putting this in the contract, I don't get. Let me explain. Getting written change orders is important. I think it's the most important thing to do. So I recommend to clients many times that, you guys have to keep projects moving. I recognize you can't just stop a project and then go back, type up agreements and send it. We recommend getting that, they used to call it, I think, NCR paper, where you have the white, the yellow, and the pink. And you can draw it up on there, at least better than nothing, as to what the homeowner's requesting. And then you at least do a ballpark description of the scope, the date, and the price to be charged. You might be off a little bit, but it's better than nothing. And then they could agree to it. If they don't, you can basically write on there that you proposed it and they rejected it. It gives you a good documentation of what was discussed during the project. But it's very important to get written change orders when you can. The problem is when you require it. I'm in 3 cases right now litigating where in the contract it required written change orders. The problem with the clear and convincing standard. Think of it this way. When you're in court, you all hear about the standard about beyond a reasonable doubt. That's criminal. Then you might hear preponderance of the evidence. That's when it's more than 51% more likely than not. That's the lowest standard to prove your case. You have to prove it's more likely than not what your contract was, what your scope, your prices, that you substantially performed, you credit the amounts due, and then you have your amount due. However, if you have a written change order requirement, meaning signed written change order requirement, and you don't comply, that standard jumps to clear and convincing, which is somewhere between preponderance and beyond reasonable doubt. But it's a higher standard, all because you, and most likely your contract, you included a written change order requirement. Get it out of there. That doesn't mean I'm telling you not to do it, though. Always make sure you try to at the best you can, even if it's just an email. Nice thing about phones now is you can email to the client, the customer, your written proposal, and then basically tell them that if you agree with this, just send me an email back saying you agree. Right now with litigation, you can have a full-blown contract basically with a battle of documents with emails. And so if you send at least a quasi-detailed email with a scope, price, and they email, that's great, and then you call it change order number 1. Boom, at least you have something. Just don't make it a requirement. It becomes very difficult litigation to prove by clear and convincing evidence, and it's clear and convincing evidence that they waived the written change order requirement. So get rid of them, but follow them. It's kind of unusual to tell someone not to put in the contract, but do it anyway. But I'm doing that to you right now. Next, mechanics liens. Okay, this seminar could take a lot longer, but you need to understand that mechanics liens are a very powerful tool. They, in essence, allow you to have a non-consensual pre-judgment lien on someone's property because you fill out a form. Now, I'm not going to get into all the requirements of a subcontractor versus non-contractor, but it actually, think about it. You guys have seen this all done. If you're a subcontractor, you have to serve your subcontractor notice on the owner and the financial institution, the mortgage companies. then you got to record a claim for lien, verified under oath, against the property. Very simple. But you don't realize with the litigation I do, there's very few areas that have non-consensual liens. It's very similar to a mortgage, but remember, a mortgage is consensual. The property owner literally signs to the lender, we hereby give you a mortgage as security for the note. The Mechanics Lien Act says that even though the owner hasn't given you the consent, hasn't given you the authority to put a lien on, you can do it unilaterally. Now, of course, there's a lot of rules, there's a lot of consequences if you lie. I get that. There's even misdemeanor charges if you do it too, if you overreach too far. But it's a very extreme concept that everyone forgets how extreme it is because it's been around since the late 1800s. So keep in mind that it's great to do it, and it does have teeth. You can have it in, it ties up the property, but I cannot believe the number of clients who call me and think that if they put a lien on the property that the owner can't sell it. They can sell it, just subject to the lien, or they can even bond over it now. So we're going to get to a little bit more detail. Can you enforce a waiver of mechanics lien rights in contracts? No, you cannot write in your contract that they waive lien rights. That is not permitted. It's in the act, and then there's a case called RWD that the Supreme Court said you can't do it. So you got a statute that says you can't do it, and now a Supreme Court decision, Illinois Supreme Court, that says you can't do it. So don't do it, because it's not enforceable anyways, and you're just giving yourself a false sense of security. If you're like an owner with trying to get you to waive it, or a general trying to get a subcontractor to waive it. I did skip one part about invoicing regularly. I missed it in my outline somehow, but invoicing regularly as a project goes along is great evidence if you're going to court. Because think about it, if I keep invoicing somebody and they never object to an invoice, and then they keep having you work, and then at the end they now object to your invoice, that is very effective cross-examination technique to try to get them to convince a judge that they're just making this up as a pretextual reason not to pay you, because they should have objected when you first submitted the invoice. Now, back to the Mechanics Lien Act. For private jobs, I'm not going to get into public jobs for bonding company, for like municipalities, school districts, IDOT, that type of thing. But for private jobs, if you are considered a contractor for either owner-occupied or non-owner occupied commercial, what do you have to do? This is the part that's weird. For a general contractor, you don't have to record a claim for lien. It's either record a claim for lien or file a lawsuit within 4 months of the completion date. But if you file the lawsuit, you also file something called a lis pendens, which is a notice that you record against the property. And then the claim for lien has certain requirements in there. I have a tendency to be very detailed on my outlines, and we had included that here. So you guys can read my outlines and have a source as to what the requirements are. Now, the subcontractor has to serve a subcontractor's notice on the owner and the financial institutions within at least 90 days. Generally speaking, there's an argument for residential within 60 days, but it says it's a requirement, but it's not. It just says if the owner's prejudiced. So generally speaking, it's within 90 days of the last day you did substantial work on both the owner and the financial company and the financial institution, and then still record a claim for lien within 4 months. And again, the requirements of a subcontractor notice I have in my outline and the claim for lien are here. So again, I also pointed out how the public jobs you're not supposed to do. And sorry about that. I keep forgetting to move the screen. And so public jobs, yeah. So it's beyond the scope, but we can have another seminar down the road that's a lot more complicated sometimes, doing liens against the federals and the state municipalities, but it can be done. Now, this is the part I want to talk about. A lot of my contractors clients get into the Home Repair and Remodeling Act. I don't have much time, but there is a Home Repair and Remodeling Act, which is a subsection of the Consumer Fraud Act, which generally requires that you have written contracts that has to have basic certain elements in it, and that you have to give what they call a consumer rights brochure to the property owner. This is for consumer transactions, residential properties, generally speaking. You have to comply with it. Otherwise, it kind of gives them an open door to file a counterclaim against you for a violation of the Home Repair and Remodeling Act, or more importantly, the Consumer Fraud Act, which is a derivative of the Home Repair and Remodeling Act, or the vice versa. It has some consequences, though. They can sue you individually under the act, even though you're a corporation or an LLC, and it provides for attorney fees and punitive damages. It's not automatic. There's the K. Miller decision that came down that says just because technical violations you can't enforce your contract or that you automatically lose. That's not true. But it gives them arguments. It can be problematic. The Illinois Attorney General's website has an excellent section on it. I send clients there all the time. They even have an example form that you can give them with the acknowledgement form that you can hand to the customer to have them sign, showing that they got or that they received the consumer rights brochure. And it even tells you the terms that you should include in your contract. So basically, make sure you look at the requirements of the basic terms to be included in the contract. Make sure it's in your contract. Don't give a consumer the right to use that as a defense against you, even though it's not as automatic as it used to be. So, okay. Yeah, these are the sections of the written requirements. I put it in here, the consumer rights brochure, and this is for any action. And then you also have insurance requirements. If you don't have that, they can also sue you individually, even if you're a corporation or LLC or other form of limited liability entity. So again, there's a lot in here. Smith Bogard was the case that was destroying my clients for a while, where there was an absolute bar to recovery for a while until the K. Miller case that I told you about basically eliminated that. So if you don't know about the act, go to the website and look it up, print it out, and hand it to all your customers. Just get in the habit of doing it and what have you. So I think that's the 20 minutes. I know it's a lot of information, everybody, and I try to get through it as much as I can. I'm used to doing an hour for these seminars, and I think I'm supposed to open up the door to questions, which I am more than happy to answer. And I think
right now we do not have any questions. I'm sure that what will happen is people go, "Oh, I should have asked that question during the webinar." But there's
I'm more than happy to answer clients' questions regularly. My father and I were the other Edgerton. We've always wanted to make a good living, but we always want to answer people's questions when they call. As I tell clients, if I can answer the question off the top of my head, I generally don't charge. It's when I have to do real work, like draft something for you, is when I start charging. But if any of you have any questions that you want to ask, please just give us a call. We're more than happy to try to answer your questions. And I am honored to be here today. It is weird speaking into a screen and not seeing any, wonderful faces to get to know. But it's the best we can do nowadays, I guess. And hopefully someday we can do this in person so I can meet some of you. So I thank you for having me.
Absolutely. In our last screen, we're going to be conducting 2 more webinars this year. Ariella
did tell me I was supposed to bring that up, and I apologize. There are 2 more. What happens after I record my lien, which I'll get to more. And then even though the next seminar on September 13th says don't sign a release unless it has this one thing, I kind of changed it a little bit on Ariella. I'm calling it issues to consider when signing and providing waivers of liens, contractor statements, and release of mechanics liens. Because as many of you contractors know, they kind of all are interrelated, and it's important to understand the differences. Sorry about that, Ariella. You did ask me to say.
No, it's great, just so everyone knows our next webinars. And you did such an amazing job in such a short period of time, and I want to thank you so much, and we're honored to have you as the attorney we work with in Illinois. So I hope everyone has a sunny day, and thank you again.
Thank you, everyone.